everyone. My name is Beverly Allen. I'm a Tacoma-based family law attorney, and I've been practicing for 10 years. And today I'd like to talk with you about what you do when you've been served with family law papers. So first, take a look at what you've been served. Read it, open it, and see what the petition is and what the summons is. The petition is the document that legally starts someone's case. Now, as you're looking at the document, you want to look in the top right corner. That will tell you the case number. That will also tell you the name of the document. And again, the petition starts the legal proceedings. So it might be a petition for dissolution, which is a divorce, a petition for legal separation, a petition to establish a parenting plan. There are many different types of petitions, but you want to see what the caption says the document is, and you also want to make sure that it has a case number. A case number means it's been filed, and then you'll want to read through the petition in order to determine your response. After you've identified the petition, look for a document called the summons. The summons will tell you how long you have to respond to the petition, and it will also tell you where to get the forms to respond. Now, as you're looking for forms, there are a couple of places you can turn. Pierce County Law Library does sell packets of forms that you can turn to in order to help you file your case. There is also a website. Washington Law Help is a nonprofit site that has different packets, but www.courts.wa.gov/forms has a list of all the mandatory forms in Washington. For the most part, family law cases in Washington state require the use of the mandatory pattern forms. And this means that you also need to use the mandatory pattern form to respond to the petition. And again, the summons, where you find that. The summons also tells you what court to file into and where to send your response to the petitioner. The petitioner is the person who filed the case. You, responding to the case, are going to be the respondent. All right, so once you've identified the form that you need, take a look at the petition. Your response is going to mirror the petition. In other words, under part 1 of the petition, you'll have a part 1 in your response. You will have 3 choices. You either agree to the information presented, you disagree, or you check I don't know. If you check disagree, you are required to explain to the court why you disagree. Now, when I'm filling out responses, most of the time, the petitioner has been correct about things like jurisdiction, the date people got married, the date the child was born. Those are pretty easy areas to check I agree on. However, be very careful when you're responding to things like property division, debt division, restraining order, child support. These are areas that if you want the court to adopt your proposal, you should check disagree. And you don't have to offer a long explanation. You just need it on the record that you disagree and you want the court to adopt your proposal. Sometimes when I'm drafting for my clients, that's all I say. So once you complete your response, you'll need to file it with the court and you'll need to send a copy to the petitioner. For Pierce County, I highly recommend you get a Lynx account. LINX, all caps, is what I search for when I'm Googling it. And it's the Pierce County e-filing system. It's one of the best e-filing systems that are out there, if not the best. And there's a separate video on the Pierce County Law Library site to tell you how to access and sign up for a Lynx account. There's also a Lynx help desk with some very helpful people. So sometimes I get the question of, do I have to respond? What if I don't respond? Have I been served properly? And here's what I'll say to that. If you attempt to avoid service or you are avoiding service, you are not avoiding the case forever and ever. What you are doing essentially is one of two things. Either the petitioner is going to tell the court that you did receive these documents, and that could involve perjury. They might tell the court that they've served you when they haven't, and the court might enter final orders against you. Or the petitioner will turn to the court and ask the court for permission to serve you by mail or by publication. And if that is granted, the case can finalize by default, meaning without your participation, and those could be valid and binding final orders. So you probably can't delay your response forever. However, you could point out to the court that you haven't been properly served, and you could force the petitioner to properly serve you. So if the petitioner physically handed you documents, that is not proper service. If the petitioner sent you certified copies, even if you signed for it, that is not proper service either, unless there's an exception by statute, such as a notice of intent to relocate. That is a document that you can serve via certified mail. But a divorce, a separation, a parenting plan, those have to be personal service. And even though certified mail does require a signature, that is not the same as personal service. If that is what the petitioner tells the court happened, they will make personal service happen, or they will make the petitioner file a motion to serve you by mail or by publication. If the summons you've received says that you have been served via mail, and that is an approved summons by mail, then you have additional time to respond. For summons by mail, I believe it's 60 days. For publication, it is 90 days. Out-of-state service is 60 days as well. You'll want to double check the summons, because the summons will tell you how long you have to respond to the petition. And make sure you are filing the response in those deadlines. If you've alerted the court to your existence in any way, and I've seen this include a notice of appearance, or even a letter, or even you showing up at a proceeding, such as an ex parte proceeding. But if you've been part of the case, then the case cannot finalize by default without the petitioner setting a motion for default and giving you notice of when that default hearing will occur. But don't just trust luck. Make sure that you're filing a response and not just waiting around for that motion for default to be served to you. Make sure that you follow the directions and file correctly. You also might want to consider simply accepting service. It depends on how contested the case is. It depends on how far apart you are. But at some point, you might be asked by the petitioner or their attorney, will you sign an acceptance of service? That does not mean that you agree with what the petitioner is asking for. It only means you agree that you've gotten the documents. Now, once you have that piece closed up, once you do the response, at that point, the court can set a trial date. So that helps move things along to a conclusion, but the court will go from the date that you have accepted service or been served to determine how soon the court can close the case. For dissolutions, there is a 90-day waiting period for the time that the petitioner filed and served, and the time that the court can close the case if it's by agreement or if there's a mediation at some point in that 90-day period. So in other words, if you're pretty close on the details, if you've agreed to go to mediation, and by the way, I highly encourage mediation to resolve disputes, then you might want to think about signing an acceptance of service, because that means that you have less time to wait for the court to finalize the case. If you insist on a personal service, and especially if you let the court know that you have not been correctly served, because let's say they sent you a certified mail, or let's say the petitioner handed you themselves the petition and you don't sign an acceptance of service, then you delay that time period for the court to finalize how the petitioner has correctly and accurately served you or gotten permission to serve you another way, such as a motion to serve by mail. So I hope that clarifies your obligations as a respondent. Again, the Pierce County Law Library has the forms that you need. Washington Law Help also is a great resource, and courts.wa.gov/forms is also a great resource. My name is Beverly Allen. I have a business, the Tacoma Legal Coach, and the law office of Beverly Allen. I'm here in Tacoma. I'm happy to take your calls. My phone number is 253-778-6376, and my website is www.tacomalegalcoach.com. I hope this information has been helpful, and thank you for watching.